The Fifth Circuit just did something wild with suppressors, and it's got the DOJ tripping over itself like they just realized they've been arguing the wrong side of history. I'm talking about a court pulling back its own ruling, the feds flipping their stance, and that old $200 tax stamp that's been hanging over us since 1934 finally circling the drain. What's up? This is Luke from Line 45. Today, we're talking about how the Fifth Circuit just yanked their own suppressor ruling. The DOJ folded like a cheap lawn chair, and that $200 tax stamp we've all been stuck with since the Great Depression might finally be on the chopping block. Before we dive in, do me a solid. Smash that subscribe, tap the bell, hit all the dang buttons down there. You don't gotta, but it keeps this train rolling and lets me crank out more of this wild gun talk for y'all. Alright, enough of that, let's get back to it. Did the court pull a 180? The Fifth Circuit dropped a big one in February 2025 when a three-judge panel ruled that suppressors aren't arms under the Second Amendment. They said silencers were just accessories, not protected like rifles or handguns. That decision lined up with older cases where courts dismissed suppressors as optional add-ons, even though they've been regulated since the 1934 National Firearms Act. But here's the kicker. Just weeks later, the court withdrew that opinion. Published appellate rulings almost never get pulled once they're out. It only happens if there's some major problem, and in this case, the trigger was the Department of Justice. The DOJ asked the court to pause because it wanted to rethink its legal position. That request alone is unusual, but the court actually granting it shows how shaky the original ruling was. Why does that matter? Because the DOJ has been defending the NFA for decades. They've always argued that silencers don't fall under the Second Amendment. For them to backpedal this hard means the Bruin test is hitting like a hammer. The government suddenly realized that if they stuck to their old line, they'd risk the whole case going up to the Supreme Court and nuking suppressor restrictions nationwide. So when that opinion got yanked, it wasn't just a routine correction, it was a signal. The DOJ flinched, and the courts gave them space to rewrite their playbook. That's the moment the suppressor fight flipped from business as usual into uncharted territory. From solvent trap to supreme fight. This whole mess started with one guy, George Peterson, a federally licensed gun dealer out of Louisiana. The ATF came after him for selling what they called solvent traps. If you don't know, a solvent trap is basically a cleaning accessory, but the feds argue a lot of those kits are really unregistered suppressors in disguise. Peterson got indicted for selling them without going through the NFA hoops, and that's what lit the fuse for this case. Now here's where it gets interesting. Peterson's defense didn't just argue the usual technicalities. His lawyers brought up the Bruin decision from 2022. Bruin says if the government wants to restrict something under the Second Amendment, they have to prove it matches some historical tradition of regulation. And guess what? There's zero evidence of suppressors being regulated at the founding or even in the 1800s. The first big law hitting them was the 1934 NFA, which came out of Prohibition-era politics, not history. The defense basically told the court, if suppressors make firearms safer to use, quieter, and easier on hearing, why should Americans have to pay a tax and register them like contraband? Under Bruin, if there's no historical tradition, the law falls apart. That put the Fifth Circuit in a tough spot. So what started as a local bust on a dealer turned into a high-stakes constitutional test. It wasn't just Peterson fighting his charges anymore. His case became the vehicle to answer whether suppressors get full Second Amendment protection. And once the DOJ flipped its stance, the whole thing escalated from a simple prosecution into a showdown with national implications. The hammer dropping on the NFA. Bruin is the game changer here. No cap. The Supreme Court in 2022 made it crystal clear that the Second Amendment isn't judged by whether politicians think a law is reasonable. The only question is this: was there a historical tradition of regulating that same kind of weapon or accessory back when the Second Amendment was ratified, or even around Reconstruction? If the government can't find a legitimate tradition, the law doesn't hold up. Simple as that. Now, look at suppressors under that test. They weren't even invented until 1909, when Hiram Percy Maxim patented the first commercial model. Nobody in 1791 or 1868 was banning them because they didn't exist. The first time the government got involved was the National Firearms Act of 1934, and even then, it wasn't because silencers were some major crime threat. Congress slapped a $200 tax on them because of fears tied to poaching during the Great Depression. That tax was insane at the time. It was about the price of a brand new Ford car back then. So under Bruen, the government has got nothing. There's no founding-era law, no Reconstruction-era law, nothing even close to a tradition of banning or heavily restricting suppressors. All they've got is a 20th century revenue scheme that was more about stopping poor folks from hunting than stopping crime. And that's exactly why DOJ's old arguments started collapsing. The Bruen test put the NFA's suppressor rules on the chopping block, and the courts suddenly realized they couldn't hide behind public safety anymore. The law has to line up with history, and suppressor bans just don't. The DOJ folds. Here's the part nobody saw coming. Back in February 2025, the DOJ was still running with the same old line. Suppressors aren't arms, they're just like a scope or a sling, and the Second Amendment doesn't cover them. That's the same argument the government has used for decades, and it worked before because courts went along with it. But this time, with Bruen hanging over their heads, that playbook wasn't cutting it. By spring, the DOJ did something wild. In May 2025, they turned around and flat out admitted in their new brief that, yeah, even if suppressors are accessories, putting restrictions on them still burdens the right to keep and bear arms. That's a massive flip. You're talking about the same Department of Justice that defended the NFA since 1934, suddenly conceding that their old stance was legally shaky. That doesn't happen unless they know the higher courts, maybe even the Supreme Court, are ready to shred the old logic. Think about what that means. If the government itself is saying suppressor restrictions weigh on the Second Amendment, the whole fight shifts. It's no longer just Peterson's defense saying the law doesn't hold water. The DOJ practically admitted its own case is flawed. That's like your ops in the ring throwing punches at themselves. So the court pulling back their opinion wasn't just a legal technicality. It was the DOJ waving the white flag on a key argument. And once that concession hit the record, the fight over suppressors went from being about accessories to being about core constitutional rights. The $200 tax scam is dying. Here's where Congress jumped in. On the 4th of July 2025, the president signed what they called H.R. 1, a giant one big beautiful bill that tucked in a massive change for gun owners. Buried in that legislation is the death notice for the NFA tax stamp. Starting the 1st of January 2026, that $200 tax on suppressors, short-barreled rifles, and short-barreled shotguns is gone. Just gone. That's huge, because that tax has been the single biggest barrier to owning these items for almost a century. When the NFA passed in 1934, $200 was brutal. You could buy a brand new Ford car for around the same money. In today's dollars, that's like forcing somebody to pay close to $5,000 just to exercise a right that's supposed to be guaranteed. And on top of that, you had to go through a long background check and wait months just to get approval. That's why most people never even try. It wasn't the suppressor itself that scared folks off. It was the hoops and the wallet drain. Gun rights groups and industry players have been hammering Congress for years, pointing out the nonsense of calling it a safety measure, when it was really just a tax scheme. And the numbers back it up. Suppressors aren't crime guns. They're hearing protection tools. Even the DOJ knows that now. So, with H.R. 1 signed, we're staring at the end of one of the oldest scams in American gun law. After January 1, you're no longer paying an outdated tax just to screw a can on the end of your barrel. NFA dominoes suppressors first, so what's next? Here's the crazy part. Suppressors are just the opening shot. Right now, there are about 4.8 million lawfully registered suppressors in America, according to the ATF's own numbers. And the FBI's crime data shows they barely ever turn up in criminal cases. We're talking roughly 44 incidents a year, out of millions in circulation. That's a crime use rate of about 0.03%. If you stacked those odds in Vegas, the house would laugh at you. That's why the government's case always felt weak. So what happens next? Well, once the courts and Congress admit suppressors were never a real threat, the rest of the NFA is looking shaky. Short-barreled rifles and short-barreled shotguns are already under fire in other lawsuits, with plaintiffs pointing out there's no historical tradition of regulating barrel length either. Same Bruen test, same lack of evidence. And once the tax stamp is dead, the only thing keeping those items locked down is the registry itself, which is already getting challenged. There's also the big elephant in the room, machine guns. Full auto is still capped by the 1986 Hughes Amendment, but if the courts keep hammering this historical tradition standard, you can bet that fight's coming too. That's the domino effect people are talking about. Suppressors are the wedge. They're quiet, practical, and statistically safe. And now they've forced the DOJ to back off. Congress to step in, and the courts to rethink decades of gun law. If one domino just fell, it's only a matter of time before the whole NFA structure starts tipping.